Hi friends, today we will see about the shareholders agreement. Shareholder agreements are quite common in business. In India, shareholders agreements have gained popularity and currency only lately with the bloom of newer forms of business like the family companies, joint venture companies, capital investment companies and private equity investments. Okay, shareholders agreement is a contractual agreement between the shareholders of a company describing how the company should be operated and defining the inter se shareholders' rights and obligations. SHAs are the result of mutual understanding between the shareholders and the company, to which generally becomes a consenting party. Such agreements are specifically granted to provide specific rights, impose definite restrictions over and above those provided by the Companies Act. SHA grants creates a personal obligation between the members signing such agreements. However, such agreements do not become a regulation, just like articles, unless the articles are amended to incorporate the provisions of SHA. Okay, now talking about the enforceability of shareholders agreement. The shareholders agreements as per US courts are accepted. Actually, the House of Lords found that though a company cannot deprive itself of its power to alter constitution, the members of the company could have agreed in a shareholders agreement as to how they will exercise their voting rights. While in India, this is not so. In India, courts have either refused to recognize clauses in shareholders' agreements or even if they are consistent with the company legislations. And in a very small cases, they have enforced it only if the clauses of shareholders' agreements have been incorporated in the Articles of Association in India. Okay. Otherwise, the Indian courts do not find this shareholders agreement enforceable by the Indian courts. Okay, in the famous judgment of Supreme Court of V.B. Rangraj versus V.B. Gopal Krishna, even the courts held that a restriction which is not specified in the Articles of Association is not binding either on the company or on the shareholders. And the basically now we can discuss about the newer agreements the SHA contains. It will contain like how equity will be split when someone leaves or when profit starts flowing. How will the company react if the co-founder walks away in 6 months? Then if